marked by simplicity and confidence. He inspires us and guides us in each and every step. I invite Advocate Sudhir Kumarji, State President, ABVS North Tamil Nadu, to give welcome address for this session.
Good morning, everybody. On behalf of Akhila Bharat Vazhakkariஞர்கள் Sangam Tamil Nadu North, I welcome you all, our national office bearers, other Karyakartas, Adhivaktas from Kerala, Tamil Nadu North, Tamil Nadu South, and Puducherry. In this session, we have an important topic: public interest petitions on various levels. We have a good speaker and a wonderful speaker, none other than Additional Solicitor General of Madras High Court, Shri A.R. Sundaresan ji. I welcome him. I welcome you, sir. I welcome other dignitaries herein. And for this topic, I think we have called the most experienced person regarding PAL, because in his private practice also, he has done wonderful cases on PALs, and now he is defending Union of India in PAL matters in Madras High Court. So he is a much rich experienced person on this topic. I welcome him, and I welcome all Adhivaktas of various states. Thank you for the opportunity to welcome him. Thank you all.
Thank you, Jay. I request Advocate Shri Palani Kumarji, Zonal Samyojak, to honor our guest, Shri A.R.L. Sundaresan, Senior Advocate and Additional Solicitor General of India. I request Prasad ji to honor our guest, Shri A.R.L. Sundaresan, Senior Advocate and Additional Solicitor General of India. I request the members to give a round of applause. May I now request Shri A.R.L. Sundaresan ji to present a token of appreciation to the person Nityashri, who recited Vande Mataram and Tamil Thai Valtho. Request the members to give a round of applause to Nityashri. I now request Advocate K. Bhaskar ji, Organization I am Samyojak, to deliver the presidential address.
I warmly welcome to the respected patron of ABAP and the chairman of KC Trust, Nargunji, and National Joint Secretary Rajendranji, and National Vice President Satyaprakash Swamiji, and the Zonal Samyojak K. Pranikumarji, and other guests arrived for this training session, and every participant who has gathered here with a commitment to strengthen the legal profession and contribute to the administration of justice. India's legal tradition did not begin with the modern legislation. For thousands of years, our civilization developed principles of justice, fairness, duty, and good governance. Ancient Indian jurisprudence emphasized that law exists to protect society, maintain harmony, and uphold rightness. Our Constitution carries forward these ideals by securing justice, social, economic, and political liberty, equality, and fraternity. These constitutional promises impose a solemn responsibility upon every advocate, that means member of a Adhivakta Parishad. Today's training assumes great importance because litigation is constantly evolving. Every advocate must possess not only knowledge of substantive and procedural law, but also the ability of identify the issues affecting society at large and to use legal remedies effectively. One of the most significant contributions of the Indian judiciary is the development of public interest litigation. PL has transformed access to justice by enabling courts to protect the rights of those who are unable to approach them due to poverty, illiteracy, disability or social disadvantage. Though PLS, the judiciary has addressed environmental protection, bonded labor, prison reforms, child welfare, women's safety, transparency in public administration of the protection of public property and many other issues affecting society. However, PL is not intended to serve private interest, political rivalry or personal publicity. Courts have repeatedly held that a genuine public interest litigation must be filed only to protect public rights and constitutional values. As advocates, it is our duty to ensure that this extraordinary jurisdiction is invoked responsibility, sincerely and only for legitimate public causes. Every advocate should remember that a well-prepared PAL can bring systematic reform benefiting thousands of citizens. Equally, a frivolous PAL wastes valuable justice time and undermines the credibility of the legal profession. Therefore, research, factual verification, statutory analysis and legal ethics must guide every public interest litigation. Our organization believes that every member of ABAP have a larger responsibility towards society. The ideals of national service, integrity, discipline and respect for the Constitution inspire us to work not merely for individual clients but also for the welfare of the nation. The administration of justice becomes meaningful only when law serves society and every citizen has confidence in the legal system. We ensure that the young advocates must continuously update themselves with recent judgments of the Supreme Court and High Courts, improving drafting skills, master procedural law and develop effective advocacy. Success in litigation is built upon preparation, sincerely ethical conduct and continuous learning. This training camp should therefore become more than an academic exercise. For that, we are today the speaker, senior advocate and also additional Solicitor General A.R. Sundaresan will deliver a speech based on the public interest litigation. How can we use the public interest litigation to resolve the public issues in the court? Therefore, I congratulate the Chennai High Court and the District Court unit for organizing this litigation training camp and thank all the resource persons for sharing their valuable experience and expertise. I am confident that today's deliberations will enhance our professional competence and strengthen our commitment to justice. With these words, I extend my best wishes for the success of this training program. Thank you. Jai Hind.
Thank you, G, for identifying the crux of the issues and motivating the advocates to proceed further. Thank you, G. It is our privilege to introduce our distinguished speaker, Shri A.R.L. Sundaresan, Additional Solicitor General of India, most lovable, eminent jurist, calm, quiet and humble person, who is the captain leading the team of law officers efficiently and effectively. He is a person who does not miss any of our ABVS functions. Thank you, sir. There are many reported judgments in various journals. He is a person who is always leading the team like a Captain Dhoni, and young in age as Vaibhav Suryavamsi. At any last moment, he saves the ship and safely bringing us to the shore. He does not say no even at the last moment of engaging him for any sensitive matters. He gets the brief inside the court itself and helps us all to face the case. We are honored to have him with us today and look forward to his valuable insights on the role and significance of public interest litigation. With great respect, I invite Sri A.R.L. Sundaresan Ji to kindly address the gathering.
respected friends, Rajendran ji, other doyens sitting in front of me, my dear friends, ladies and gentlemen. Good afternoon to one and all. I am really honored to have been invited to this ABAP function, and it's really a good thing to have such sessions periodically so that we keep ourselves updated. There is exchange of views, there is exchange of knowledge. Today everything is there in live law, everything is there in the cell phones, but still I might have seen one, you might have seen one. There is an opportunity for us to exchange and we address. I learned something coming here. I try to share something which I have, which you might not have read or you might have missed it. So we should congratulate the organization for convening such functions, inviting people to speak and inviting me to sit here and learn. Thank you. And so far as the subject public interest litigation is concerned, you just keep the word PIL in your mind. It may be public interest litigation. It may be private interest litigation. It may be publicity interest litigation, or it may be political interest litigation. Now courts started this. See, Article 32 or Article 226, the person aggrieved can come to the court, is what the Constitution says. Article 32 for violation of fundamental rights. Article 226 for any order, violation of constitutional rights or any other order against the state or any authority. It is wider. But then it is only the person aggrieved who can come. The exemption which was given is that the word which is used by the lawmakers, that is the judge-made law, created this public interest litigation. They said that little Indians who may not be able to approach the court, but they are suffering violation of fundamental rights, violation of human rights, they will have to be protected. Who can do it? There, the public interest litigation theory had come up. Therefore, it is really only for the downtrodden, scheduled caste, scheduled tribe, people who are not able to come to the court, who are not able to spend, who don't have access to justice, who may not have the best of lawyers, and the cause of such persons is allowed to be handled by other responsible persons. As this started growing, then the person aggrieved theory gets diluted and people start using this for either you want to business rivalry, there is one petrol bunk, within 100 meters there should not be a petrol bunk is the guideline. But that petrol bunk staff or that petrol bunk owner's brother or sister, they will file a public interest litigation saying that it is causing risk, etc. Therefore, that is a case of misuse. So, the more you start misusing it, then the courts will become stricter in entertaining public interest litigation and then giving relief. As a result, what will happen, if the misuse by the three other PILs, political interest, private interest, publicity interest, if that takes the driver's seat and real public interest will take the back seat, courts at some point of time may come on saying that anybody who wants to come to court, let them come to court on their own, we will not entertain any public interest litigation. And courts have now started dismissing writ petitions with costs if they see that it is either because of business rivalry or because of personal vendetta or because of political causes like that. One example which I can give you, I don't know what will happen in the Supreme Court ultimately. The present government in the state had given 41 appointments or so for the persons who were victims in the stampede. The government wanted to give it as a succor to them. It is violative of Article 14. It is violative of Article 15 and 16. Several people who are unemployed and who are waiting in the employment exchange, they are not given. If this is entertained and it is approved by the court, then there may be a bridge collapse. There may be a building collapse. Does the government have the wherewithal to provide everyone with such employment? If that is so, what will happen to Article 15, 16? Therefore, it is a genuine case. Even though it's a genuine case and the division bench of the Madurai bench of the High Court had struck it down, yesterday the Honorable Supreme Court has granted stay, and I am told the prime ground on which stay was granted is In a service matter, a writ petition in public interest is not maintainable, and the petitioner is not a person who was waiting in the employment exchange for employment, therefore his rights are not affected. How a political person or somebody come and say that others are affected? If others are affected, those others are capable of coming to court. They will come to court, they will challenge it. Therefore, a good cause which would have been set aside for the very same reason at the instance of a person aggrieved, out of anxiety somebody goes to court and then gets a success. That success is short-lived. Ultimately, if it is set aside, then tomorrow a really aggrieved person may not come, because it will become res judicata, all issues will be decided. Therefore, before filing a public interest litigation, we will have to be very clear. The reason is, if you file a public interest litigation and get a verdict, that verdict is going to become a judgment for that cause. If you do it well and the court entertains it, yes, you are delivering something to the person who needs it. But if you don't do it well, or the court dismisses it, then subsequently the really aggrieved person may not also be able to come to court. You will be causing some negative aspects, or under the guise of doing something good, you may land up doing something bad for the person who really needs it. Therefore, we will have to be very careful, and this is from the point of view of the petitioners, where we have to really, and the Madras High Court has got public interest litigation rules. Under those rules, you will have to declare that you don't have any personal interest in the cause. You will have to give your Aadhaar card, you will have to give your PAN card, you will have to disclose what income you are having. You will also have to give an undertaking that in case the court holds against me, I undertake to bear the cost, I undertake to pay the cost, abide by such conditions as the court may impose. And if a public interest litigation is dismissed, subsequently that will be noted, and future public interest litigations, even for a genuine cause, you may not be able to file. Because they say that earlier what has happened, how many cases you have filed, how many you have lost, how many court has imposed cost, all those things also you will have to declare. Therefore, public interest litigation is a very powerful tool, but to be sparingly used in the fittest of cases, so that you don't land up, when we are appearing as advocate, we will have to advise the clients. Better you do it or you don't do it. Advise him properly. Otherwise, what is a tool which is very strong may also be allowed to be misused. And if it is misused, it is against the system. As my friend said, it is waste of judicial time. The same time the court could have taken for handling a few other cases, and litigants who are waiting for that, they'll be able to have those cases heard. Therefore, consuming the court's time with a frivolous litigation is something which has got to be avoided. As law officers, as advocate, we will have to decide on that. And when we are appearing for the state, when we are defending cases, it is our duty to bring it to the notice of the court. Either this is something which the state will do, we will take care, we don't require a public interest litigation for this. Why should there be a writ petition saying that you please maintain this river, you maintain the forest, etc. As law officers, we can tell that the government is well aware of that, we will do whatever has got to be done, therefore it need not be entertained and it need not take the time of the court. We are not failing in our duty. Get all that has been done by the department and the plans which we have, place it before the court and see that that is recorded, and then the case is closed, so that the time of the court is also not wasted. From the point of view of the society, where public interest litigation is really necessary, as my friend said, that prison reforms, protection of children, protection of women, protection of downtrodden, the tribals, etc. Now, what is happening in Andaman Nicobar, those tribals may not even know where the court is. Those tribals may not even know what rights they have under the constitution, what statutory rights they have. Such persons, they require the voice of somebody else to come to the court. Like that, mass destruction of houses, mass demolition of houses, slum clearances, those people, they need the support of public interest litigation. And coming to nature, we and the government are all trustees who are holding the earth, water, air, trees, animals, everything in trust, so that they are protected and they are allowed to grow and they are nurtured and we present it for the future generations. If that is not being done in a particular place, then it is the duty of the citizen to bring it to the notice of the court and ensure that the directive principles of state policy with regard to environment, with regard to the Ministry of Environment, etc. They are all acting, and then they are all taking care of the natural wealth and minerals exploitation, the right to light, right to shelter, right to water. All these are now treated as a right under Article 21 for a decent living. If that is deprived in a particular village, the village does not have water, the village does not have sanitation, they don't have toilet facilities, they don't have proper schools. These are causes which I would suggest that our members themselves, if they identify any particular place where these are lacking, give representations to the government, bring it to the notice of the MLA, bring it to the notice of the MP, bring it to the notice of the concerned ministry, either in the state level or in the center, and then take up those causes. The public interest litigation at various levels is what the topic is. Therefore, public interest is not only within the four walls of the High Court or four walls of the Supreme Court. Public interest can penetrate to the grassroots level. It can start from the taluk level. It can start from the district level. It can come up to the state level and go up to the national level. Therefore, wherever these basic necessities are lacking, we will have to see that somebody takes up the cause in the right interest, not in the interest of a contractor who will get the contract for doing that work. And sometimes it happens that if a tender comes, then somebody will be able to bid in the contract and then he will get it. And then keeping that idea in mind, starting, therefore, it should be purity interest litigation. Public interest litigation should be pure interest litigation, interest of the downtrodden, which has got to be protected. Earth has to be protected, therefore we will have to fight for that. Water has to be protected, we will have to fight for that. The voiceless, who will fight for the elephants? How many writ petitions were filed in the High Court to protect the elephants which are there in the camps which did not have proper medical care, which are there in the temples which did not have proper medical care? Nobody can say that they should not be there in the temples, they should not be there in captivity. Only thing is, wherever they are, they should be taken care of. The natural environment in which they can live, that environment should be created for them and they should be protected in a way in which they would like to live, not in a way in which man would like to keep it. If you want to have pets at home, if you want to have elephants in the temples, if you want to have elephants in the gardens, in the parks, then public interest litigation have been filed where the courts have come up and then they have solved the situation. The voiceless is being protected. Like that, medical facilities. If medical facilities are not available, then several writ petitions have been filed for having primary health centers opened, for having, and there are also cases where peculiar diseases, 1 in a lakh or 1 in a crore, it may happen. It requires about 1 crore to 2 crores of expenditure. Recently a case is being handled by the Supreme Court. Supreme Court says that 2 crores already it has been funded, another 1 crore is required. Let the government consider and then provide those funds. These are all areas where the court should spend time on such cases, and court should nip in the bud the other cases which are coming up. Every day if you sit in chief court, you will find at least 8 to 10 writ petitions are being filed as public interest litigation. And out of 8 to 10, at least 2 will be service oriented, 2 or 3 will be personal interested. You will be a member of a society, that society will be doing something wrong. You will file a writ petition exposing that. Ultimately it will be found out. 1 writ petition would have been filed by 1 member and it would have been dismissed. 2 days later, the same typeset of papers, same page numbers, filed by another counsel in the same chamber in the name of another member. How long will it take for the respondent's counsel to say that please compare that typeset and this typeset? These are all cases where what we should think is that the object of public interest litigation is something which is intended to deliver some to the needy people who may not be able to come to court. We should not use it as a weapon to wreak vengeance against people whom we don't like or business rivalry like that. Therefore, I would appeal to this august gathering that when you are defending a case, identify cases which are an abuse of process of law and fight tooth and nail to see that what is required to be done will be done, even if this public interest litigation is not there. But the idea behind this public interest litigation is something other than what it projects. Make that bring that to the knowledge of the court and see that it is dismissed with cause. This is if you are appearing for the respondents, but at the same time, when you are appearing for the respondent state and it is a genuine cause relating to health, child welfare, women welfare, protection or protecting the environment, we will have to travel along with the court. We will have to convert ourselves as amicus. We should start not like identifying ourselves as a counsel for the state and fighting it, but advise the government, advise the ministry, advise the secretary that these are all things which has to be done in the larger interest. And one thing which I can tell you, what we are now in the Madras High Court, there is a permanent bench for, it started off for Nilgiris, Justice Satish Kumar and Justice Bharat Chakravarti. They started off, and then now all the resorts in the Elephant Corridor has been removed. Plastic bottles has completely been banned, and glass bottles are not allowed to be thrown. They have taken, they only initiated the buyback of the glass bottles, and that has been now extended to various parts of various other parts of the state. That bench is continuing, and now they are introducing something where they say that water bottles which are containing edible water, the water which is stored in a water bottle will give some chemicals, and they under the FSSAI Act, Section 18 says that if anything which is going to contaminate the food particle, a warning should be given. That warning is directed to be given by the court, and the department did not agree. We advised them that under the FSSAI Act, you have to do it. It is in larger public interest. You are not banning the sale of water. You are only informed. Just like the ingredients, this contains, suppose sugar is sold or some food edible item is sold. What are the ingredients that is required to be pasted on the sachet? Like that, a warning saying that this may contain some chemicals, a percentage. That has got to be done. The department did not agree. We went to Supreme Court. Supreme Court said, no, what is this? It's only in public interest you have to do. FSSAI Act gives you the power. And your own reports say that it contains. When it contains, what is wrong in informing the public that there is a likelihood? Therefore, these are all things where we also have to advise the government, advise the department, and see that public interest litigation as a tool is used for the best purposes, and the opportunity is used for larger interest and larger public interest, and either private interest, political interest or publicity interest is avoided. Thank you very much.
So thank you for your valuable insights. Will certainly inspire us to approach PIL with greater clarity, responsibility and a strong sense of public service. Related to grassroots level, you explained about 5 elements to protect the public affected areas, religious, land and animals, grievances to voiceless. You made it clear the objective is the needy, deserving and affected people. Thank you once again for your insightful, thought-provoking session, sir. I invite Advocate Shalini G, General Secretary, High Court of Madras, to propose the vote of thanks.
First day law school, they teach us the 5 functions of lawyers. To be an able counselor, to be a good advocate, to know the current law, to predict how the law would be, to shape public opinion, and to hold public office when it comes to you. So on day 1, we know what those 5 functions are. The rest of the life, we learn new ways to discharge those 5 functions. So here is a gathering containing lawyers who ensure that I discharge those functions, and the dignitaries on the dais and on the first 2 rows of this gathering who put the fear of God in me when I fall lacking. So, thank you one and all for being a part of this gathering. So, to conclude with, I wish to narrate two incidents pertaining to extraordinary lawyers. One is the learned ASG, and the other is our very own Babuji, who, about public interest. So, public interest litigations are filed with regard to public interest by someone who has no interest in the litigation at all, like how the learned ASG explained. There is one other litigation, there is one other function of the lawyer where he thinks about the public interest in every case. So that is where the first case comes. So there was this case relating to a passport issue. There was this petitioner who was holding multiple passports, and I was appearing on behalf of the Union of India, and I had engaged the learned ASG. I was quite confident the petitioner is going to jail. For the 10-page affidavit, I had drafted a 20-page counter affidavit, worksheets, and there I was in the ASG's office. So he read everything. He came to court and he asked me one question. Now, what's the remedy for the petitioner? Okay, he did all this, all these complaints, allegations you have against him. What is his remedy? He is a layman. He is an Indian citizen in trouble. What is his way out? So that is when I realized public interest, the interest of the common man, is the basis, the tenets of our profession. So that is how the learned ASG took the case in a way that I did not think it would go. Actually, the writ petition was allowed with liberty to the petitioner to file a fresh application with all the conditions that he had said. So he walked away with a relief. So that was the one case where I learned it was a master class on public interest. So thank you, sir, for giving that to me.
Thank you for engaging me in that.
Thank you.
I said surrender all the passports, apply afresh.
There could not have been a better senior to lead that case. And then as for the litigation IM of the Madras High Court unit, there was this writ petition that we filed, and that ended against us. And we are in the process of filing a writ appeal. Some writ appeals are filed and numbered and it's before the bench. And there is the writ appeal that I filed, it is not numbered yet. And Babuji calls me one day and he says, I want your writ petition tagged along with item 51 before court 1 today. I called my junior and he says, item 30 is going, madam, our case is not even numbered. So I called Babuji with a sad face, saying, sir, less than 20 items, sir. How is it going to be tagged along? And Babuji says, you have the lunch hour in the middle. You can do wonders. So that's the kind of a tight ship that Babuji runs in High Court. So thank you, sir, for keeping us all in line. Thank you very much.
Thank you, Ji. We shall now proceed to session 3, which focuses on the Knowledge Collective and its role in supporting the litigation IM. Adjourning the second session right now.